When people picture a judge, they often think of somebody completely fair and neutral who's acting like a referee in a hockey game, standing above the action and making unbiased calls just based on the rules. But judges are human beings, they have beliefs, values, and life experiences. And in Canada, judges are appointed by politicians who might be tempted to appoint people who share similar political beliefs. This raises concerns that judges will decide cases based on political reasons rather than the facts and the law. The good news is that judges are part of an independent branch of government, and it's nearly impossible for politicians to fire them. This means they can be true to the law, even if that might upset the people who appointed them. In this video, we'll take a closer look at how judges are appointed in Canada and how judicial independence keeps things fair. In Canada, we have several levels of court. At the bottom are provincial or territorial courts. These have names like the Ontario Court of Justice, the Alberta Court of Justice, and the Provincial Court of British Columbia. Provincial courts are created by provinces themselves, and they deal with provincial matters like traffic tickets, some family law matters like child custody, and also some minor criminal charges. Judges in these provincial courts are appointed by provincial attorneys general. When a job for a judge opens up, the province creates a judicial search committee made up of people who look for qualified candidates, usually lawyers with 10 or more years of experience, and they take into account factors like the need for racial diversity and gender balance. They then forward a list of recommended candidates to the Attorney General of the province, who reviews their resume and makes his or her choice. Above the provincial courts are what we call Section 96 courts, named for Section 96 of the Constitution Act 1867, which creates these courts. These courts have names like the Ontario Superior Court of Justice, the Alberta Court of King's Bench, and the British Columbia Supreme Court, which can get a little bit confusing since there are courts above the Supreme Court in British Columbia. The superior courts are courts of inherent jurisdiction, so they'll hear any type of legal matter that has not been carved off and placed into another court, including everything from freedom of expression challenges to murder trials to commercial disputes. They also hear some appeals from provincial courts. Despite having names like the Ontario Superior Court of Justice and the BC Supreme Court, these judges are actually appointed by the federal government. So just like with provincial courts, a judicial search committee will be formed and they'll interview qualified lawyers while taking into account things like diversity, and then they'll make recommendations to the Attorney General of Canada, who will make his or her choice after consulting with Cabinet. Each province also has an appeal court, which considers appeals from the Section 96 courts, and these have names like the Ontario Court of Appeal or the Alberta Court of Appeal, but again, don't let the name fool you. These judges are also appointed by the Attorney General in Ottawa. At the top of the system is the Supreme Court of Canada, which is located in Ottawa. The Supreme Court only hears the cases that have national importance, and its decisions are final. What the Supreme Court says binds all of the courts beneath it. There are 9 Supreme Court of Canada justices who are appointed by the Prime Minister himself or herself, also based on recommendations from an advisory committee, which narrows down the options to a short list of names. Usually these are the most experienced judges in Canada, and the appointments are a really big deal because Supreme Court of Canada judges will outlast the Prime Minister who appointed them. They can usually stay on until age 75. At the end of the day, the Prime Minister can pick whoever he or she wants, although there are some rules in the Supreme Court Act, including that judges of the Supreme Court must be able to hear cases in English and French, and at least 3 of the 9 judges must be from Quebec to ensure that there's enough understanding of Quebec's unique civil law system and culture. By convention, there are also usually 3 judges from Ontario, 2 from Western Canada, and 1 from Atlantic Canada. Some argue that prime ministers have allowed too much politics to enter the picture when they're appointing judges. For example, in 2022, Prime Minister Justin Trudeau appointed Michelle O'Bonsawin to the Supreme Court of Canada. Some argue that Trudeau chose her specifically because he thought she would more closely align with his left-leaning politics. But similar accusations were made in 2015 when Prime Minister Stephen Harper appointed self-described conservative libertarian judge Justice Russell Brown. But recall that Canada's judges are bound by the Constitution and trained to follow the law rather than their biases, and they can almost never be fired. That means they're truly independent. So, despite knowing who appointed them, You can't predict with any certainty that a particular judge will decide a case the way that the politician who appointed them would prefer they decide it, and that's a very good thing.